Hello, everyone. The topic for the day is essentials of HR compliance issues. We will be observing the compliance issues in terms of the hiring process, in short, and the discharge process of an employee, as essentially these two events in the life of an employee marks the maximum turmoil, one, and probably it leads to a lot of litigations altogether. So basically, what is the goal of hiring? Now, basic goals of hiring is to get the correct person around here, right? So first thing is the best possible candidate and have a fair selection views, which includes anti-discrimination. That means there are no discrimination issues in terms of the skin, the color of the skin, probably, or probably the religion based or anything else. Laws protecting other employees, definitely yes. There are people from the different weaker section of the societies, both in terms of economic weakness and probably of physical abilities or disabilities thereby. So these laws needs to be respected and definitely maintain the right of the company to terminate at will. Now these things are what we will be talking today. So, potential risk. Why? So, lawsuits by an unsuccessful candidate because he or she might feel aggrieved and as a result might take the company to the legal avenues of the land. So, hiring managers may be sued. This is one of the most common phenomena. Claims by your competitors in terms of competitions, your competitor corporate company, probably because they might feel cheated because you might have hired their resources in terms of employees. So, raiding employees, confidential informations, and future claim of breach of contract. These are the things that we will be actually discussing in the next 25 odd minutes. So, voluntary self identification inquiries are pre offer request in terms of race, sex, veteran status. This is all about age. Remember, this is all about age and the disability status altogether if a person has it. So post offer request is all about the age factors, veteran status. If you have worked in the army, perhaps if you have worked elsewhere in the government organization or a non-government organization, the disabilities that we are looking at it, and definitely don't about other documents that we keep on chewing it up. So these is very important. Right. So here they come. Accept applications only when there is an opening. Please don't float advertisement for an open door policy as on when on basis you keep on applying and people are going to be looked into. Don't have that policies at all. So accept application when there is a vacancy and every time you accept, set a deadline. Once one application per position needs to be understood. A person should not be encouraged to apply for more than one particular position because if he or she is applying for more than one particular position, probably he or she will not be able to deliver the best to their ability. So have a process of collection, review, storage, and application. Most of the time nowadays it is done digitally. Accommodation during the application process that needs to be understood. So now, if the applications are in, what do we do? Now we restrict or we select or we shortlist the numbers of applicants, enforce the deadlines, and only consider those who have completed applications in all format. Not only all the details have been filled in and all parameters with respect to the job description have been fulfilled. So screen for minimum qualification and examine the each application thoroughly. Screening for potential problems for employees. What are they? This might include incomplete responses. Probably the employees, the prospective employees might be hiding a situation or hiding a fact from their resume, or in other words, might have overlooked certain things. You need to understand what is employment gaps, if there are any. What if there are cases where job hopping has been done, so an employee lands up a suitable job, hangs on it for not more than 6 months, 1 year, or maximum 2 years. Again, jumps. So basically, as a job hopping, as a habit formation takes place, we have career changes where people change from one particular vertical to another particular vertical. When I'm talking about vertical, it is the industry that we are looking into it. We are talking about relocation. So thorough resume watching, viewing is very necessary. Dissect the resume thoroughly. Reason for leaving should be valid enough. Probably if there is a um, let's say there has been a termination because of the paucity of fund from the company's end, probably it is a valid reason altogether. If there are downsizing, it is a valid reason. So please understand why the reasons are of it is laid off, terminated, resigned, or personal, and probably check up with references if you have any. So that's these are things that we got to go around it with the help of transportations and probably any that can be reported. So, train recruitment and managers. What are recruitment? Basically, the HR fellow who is actually screening the resume, who's actually interviewing the prospective employee, need to understand what they are putting up on the post, probably how to review the applicants. What are the red flags? We will be talking about the red flags during the course of the presentation. Please watch the videos to the full. Protect categories. Now there are many people who comes under various kind of protection. Let's say son of the soil or the daughters of the soil in says. Then we have the federal policy, the state policy, and even the localities. They might have their own requirement altogether. So interviews, do's and don'ts. We need to follow it up, back it up every time now and then. Now this has to be understood, because let us not be unethical and let us not be biased to any particular persons. Proper documentation is the need of the hours, because at the end of the day, if there are certain litigations, your documentation is going to save your skin. Remember this thing. So use of credit, criminal, other background checks. Probably yes, this is a very valid thing. We need to do a reference check time and again. Timing of recessions, these needs to be understood altogether. We have to speak to the third party report many a times, so that comes around. Then comes mistakes to avoid. What are the mistakes? Doing all the talking. As a recruitment manager, you should not be doing all the talking. In fact, encourage the applicants to talk for 80% of the time. That will come out. The truth you will come to know more of about the applicant rather than you've been talking continuously. So asking question, that is call for an answer of yes or no. Probably have an open-ended question altogether. Encourage the applicant to speak, let him or her form an opinion. Allow the applicant to distract you from your script. Definitely yes, let him or her take the charge of the discussion flow of the discussion altogether. Not exploring reasons for frequent job change, which we need to understand. Basing decisions on impermissible basis, very true. Please understand, we need to be very polite and proficient as far as not to hire anyone who is going to bring in a lot of litigation to the company. Probably then we have done a very wrong job, wrong thing on our part. So recording observation that suggests, and with a impermissible basis for decision, probably this is one thing which can help you in the long run. If you record all your communication, record all your observations, be it on a digital medium, be it on your on your hand notes and things like that, it always helps you in the. So making the decision, when you are trying coming to a decision, you need to understand, and please, you must have formed your decision already. Now, before communicating your decisions, what I would request is to review the documents carefully once more, so you get a reaffirmation about what decision you have taken. And these can be done only when you have those documented, reviewed, have legal a consistent selection criteria, document those criteria, and probably if those document can support your decision, nothing like it, because that would make your decision much more credible. Monitor disproportionate exclusion from any protective groups. This needs to be understood, because at the end of the day, we need to have a diverse people from diverse background. That makes the company healthy. So EEOC, or equal employment opportunity, company strategic information enforcement plan. What is it all about? It is eliminating systematic barrier, if any, in terms of your recruitment and hiring is concerned. Probably we are talking about investigating individual charges as a case to case basis rather than on a systematic basis. Pattern or practice for policies and classes where alleged discrimination with a broad impact on an industry, professional, company, and geographic area need to be identified, need to be monitored, need to be focused upon. Right. So, what is a systematic discrimination? Let us understand. Facially neutral policy, like people might have facial hairs, people might be covering their faces, probably in terms of race, sex, age, and so on and so forth. There might be people who might have certain markings on their face, probably religious marking and things like that. Intent not required to prove disparate impact, and that is what is systematic discrimination is all about. It, remember this thing: employers with significant numbers of applicant or employees should review policies to determine impact. Absolute must thing. We have the discriminatory hiring barriers. What are they? Look at the snippet from the newspaper that I've just hung around for you to understand what kind of things which have been given. Let's say an help wanted. So basically, hot criteria would be credit history. Definitely, yes, we want a person with a healthy credit history so that he or she gets to get focus only on his or her jobs altogether. Educational standards, we look into it. Physical and functional test, definitely if it in an ambidextrous position, if it involves physical labor, physical and functional test is a must thing. We all want to have people from mainstream and not with a criminal background. We can obviously observe some criminal background thing, but it needs to be properly documented as such, needs to be understood altogether. But anything potentially associated with an age, like with an age, it's a health issue, probably most of the things. English only policy or a language preference, a preference for a particular language that comes around it. Many a times, organization, company, corporate would have this affinity for English as a proficiency requirement. Definitely yes, but these are, remember, discriminatory in nature. So what is it all about it? We have the social media to screen. Now we have a lot of things can be found about an individual if you watch their social media handling, be it YouTube, be it Twitter, be it LinkedIn, and we have it. Social media, almost 45% of the employees report everything on the social media, and it is very easy for you to dig up the information. It is very easy for you to research and have a pre-norm formations about what exactly is going to be encountered in hiring a particular individual. Some employers search Google as a part of a regular background check. Probably not many of them might be googled around it, but there are definite certain positions. If people are at a higher rank, people can be found on Google. In response to employer requests, the prospective employees provide usernames, password to access the social media account. Now this needs to be have properly documented, and this needs to be properly permission, a written permission is required, wherein the employee or the prospective employee shares the social media handlers the login details altogether. So this needs to be understood all, nevertheless. So we will we will talk about it every time. Now, over reliance of social media is also not good. Please understand. Over reliance is absolutely not recommended or at all. Hiring practices which are based only on social media. Remember, you can create your handling. You can have a login details, or probably you can have a number of profile in the metaverse or on the online platform altogether. So these needs to be taken into consideration. So let us get into the future guard breach. You know what terms of contract, fraud, and unfair competition goes around it. So let us have a guard against the future corruption or future breach obviously come into it. A terminated employee claims that the general rule of at will employment does not apply. Definitely, he will always claim foul, right? So the promises made at the interview either create a binding contract or prompt the employee to forego an opportunity and create an implied contract. And these things needs to be understood during the interview process altogether. Everything needs to be documented, and we need to understand there is an employment contract always in the thing. So offer letters should contain at will language as on when on basis. It should be very clear, it should be very distilled, made clear once again during the selection process, during the hiring process, and during the appointment process. So former employees claim that quit jobs or decline another opportunity based upon certain kind of misrepresentation or promises that the company might have found for a promotion or something like that. So these should not happen at all. People should be very clear about their action, and they cannot, or should I say, they do not want themselves to be facing the courts or the legal system any point of time. So potential rating claims are unfair competition. What are they? We have the tortious interference in terms of contractual relationships. Definitely yes. Business relationships. Now these things needs to be understood time and again. These tools are very fluidic in nature and might changes from one person to another person. So misappropriation of trade secrets is one of the things which all of us should have been covered with NDA or non-disclosure agreement, things like that. Conversion of property or information, breach of duties of loyalties, and so on and so forth. You need to be very firm with your duties and responsibility that has been given, assigned to you. You should live up to the expectation and the standards that the organization had set for himself. So we need to go around this rating altogether. So inquire about the obligation from your previous employer. This is very must. Why? Because this will let a ready hand, ready made information which will tell you about what kind of employee or what kind of a person one is going to hire. So commitment to a term of employment, restricting solicitation of co-workers or clients, restricting employments by a competitor. Now, this is where it needs to be understood altogether, that the candidate cannot poach co-workers altogether for a different company just because he or she belongs to that other company, and probably that is a fraud in place. So you need to understand, inquire about the obligation of the current and the former employers. Ask, I repeat, ask general questions regarding trade secret that could preclude employment. If you have any vicinity as far as the legitimacy is concerned, please drop those ideas. Please do not consider those people for your employment process. Encourage candidates to review documents of current and former employees. Defining obligations. Remember this thing: written agreement, codes of conduct, and other policy needs understood time and again. We will be talking about the confidential information. Now, every company has their own peculiar means of procuring things, about, let's say, unique ways of doing things or processing of process on the organization, and these needs to be limited within the framework of the company or within the stakeholders of the company, need not to be divested or divulged to other employers or other corporates altogether. So do not suggest the candidate that for the purpose of employer obtaining a business of competitors clients. So probably don't fidget with the database of the ex-employers, other companies. Confidential information of the competitors. Don't disclose your data to other employees. These are all confidential employees. So what we are talking about, we are talking about marketing strategy, we are talking about product services, be it the launch, be it the planning. Do not ask question designed to probably elicit any kind of trade secret or confidential information. Now, if a candidate volunteers to give certain information, please interrupt and refocus on the decision, because now these things needs to be very crystal clear, and we should be very much on the same platform of being transparent to each other, as an employer, employee, as a competitor, as a company, as a socially responsible organization. So offer letter should contain the non-disclosure agreement altogether. Altogether, the employer's confidential information should be protected at all costs. So do not ask for candidate to ask for clients or other clients whether to follow him or not, whether you're going to poach other people from other companies or not. This is unethical. Even if there is no solicitation agreement, it is a breach of common law. Remember this thing. Yes, before hiring, before appointing, please ask the employee to go for a drug test. This then probably allow the post offer altogether. Medical examination is very vital. In fact, in most of the organizations, medical examination is a must. This is a part of a standard hiring process. Probably allow post offer and job offer must be real, and medical conditions learned through medical exam can be treated very confidentially. When we come to the fag end of this presentation altogether, we'll talk about the fact. So at will doctrine, the at will means the employee can let go with or without cause. The as on when on basis, the employee can say, fine, he or she is no more interested to be associated with an organization. The at will does not mean employees can be let go for illegal reasons thereby. Remember this thing. Yes, at will cause the employee can validly say that he or she would like to part ways with the company, but for illegal reason it is not permissible, because such as discrimination and retaliation. Please remember that doctrine. I will talk about the red flags. Did I say early in the during the presentation that we'll be talking about the red flags? The layoffs of a sales force is very important. Layoff, what are the things? What is the reduction of the employment forces altogether? The termination on the single popular roof we are talking out. Usage of non-objective criteria, when objective non-objective in the sense when we don't have the smart criteria, specific, measurable, attainable, relatable, or time bound criteria. It is towards a liking of a person, probably a face, and so on and so forth goes around it, which are very much adjective or very much subjective altogether. So job not available upon return for leave. Let's say people might have gone for a leave, and then when he or she comes back to rejoin the job, and he or she has not been able to go around it. A long absenteeism or bad tardiness for the employees is one of those red flags that we need to understand. Yes, performance appraisal plays a part. What are the evaluation? What are the raises that has been permitted? What are the things that needs to be discussed around it? The protected categories, the protected activities is all the red flags that we need to go around here. Definitely yes. Now we come to the clean doctrine. Now I will be doing for the last next six slide all about CLEAN, clean. What is clean? Well, be doing it in the subsequent slides itself. Consider the facts about discipline. Stands for C. Learn what the managers, witness, documents have to say, references has to say. Is all about L. Evaluate what disciplinary action has been taken in the past from the confidential file, from the annual file, from the personal profile of the employee. Is all about E. Analyze the risk. Is definitely what decision you are going to take, what are the fruits or the burnt of it, results of it. Stands for A. And the last N stands for narrow down the potential option and probably decide the best optimum one for all. So we'll talk about C. We'll begin with C. What is the discipline all about it? The policy violation. If there are any issues or nuisances that has been created, and the performance issue, please understand this is what happened. And who are the witness? Have certain corroborated from by certain other individuals. What documentation is required? What are the timeliness we are talking about it? Definitely we need to understand these factor altogether. We'll talk about the learn or L factor. Please understand to collect informations from every stakeholder, have a 360-degree point of view. If appropriate, talk to anybody who is a witness or who might have a parting shot to it. Person who is very honest, person who has seen the things altogether in the first hand basis, have knowledge about the issues, because this is all about learning things. Talk to employees to get his and her side of the story. Every coin has two sides, so everybody will say their side of the story, and if possible document your process. Or we come into the E concept wherein we got to evaluate. Remember, we are talking about the compliance thing altogether. Most commonly forgot part of the analysis is the evaluation. Must do departmental, must discuss it with everybody within your department, with everybody in the functional, everybody in the hierarchy, in the company. Sorry, it's written out here. Yes, department, facility, company wide analysis, how the managers has reacted. So needs to be understood. Don't do we only do X2 Sally or for the last just month. Validate certain things. Then this is just an example that has been given to you as a neutral thing. Or what is the Sally situation? What are the new hire, new different situations that we go around it? The evaluate option is very important, because it might lead to litigations, it might lead to a lot of fines, a lot of compliance issues altogether. So in litigation, inconsistent is equal to disparate treatment. If there are any litigation, if there are any inconsistency, disparate treatment plus complaint is a case for retaliation. Remember this: lawyer and government agencies will ask for the applications to others, they will take advantages of it, and this is something which we will not like to go around it. So consistent enforcement also suggests fairness. That means you are transparent with each others. This is to be formatted. Consistent enforcement also suggests fairness. We come to the second part of the thing, the A part, analyze the risk. Now, please understand, whom we are talking to is the manager. What kind of person he is? Is he short tempered? Is he hot headed? Is he very soft spoken? Does he or she has a foul mouth? So, what support can we have? What are the protected categories that we are looking into it? What kind of employees we are looking having it? Are there any medical issues? What are the impact of the employees? What are the motivation that the employees has? Well, the employees challenge the termination. Are there any issues he can raise? That needs to be understood. This is very vital. Are there any issues that can be raised? So now we come to the last segment, which is a narrow down your options. Once you narrow down your option, you can, it is becoming easier for you to take a decision. Terminate, if so severance, training and policies acknowledgement, suspension, reduction in pay. There are so many options for you to go around it. How we actually treat a simultaneous situation immediately, two different. Now comes the non-compliance. Why should we have compliance? If there are non-compliance, there are consequences. What are they? We might have to pay back wages. We might to have to pay certain penalties. We might to have to go certain limitations for 2 years of detention or 3 years if willful. Now these things is enforced by the laws of the land. The court orders compliance in future is very true. And please, I am not even discussing the media repercussions that come up onto your organization. So pay plaintiff reasonable attorney fees. Cost, this is very costly nowadays. Possible individual management liability might be, compensation might be enforced upon it. Possible criminal penalties that can goes around, the diversion, the distraction, the disruption. And what happened about the media thing? Did I say about the adverse publicity that is going to corner you or probably shun you in the eyes of your public, the consumer, the end clients? Probably overall corporate image is going to suffer a lot. So need to understand this risk of miscalculation. Minimum wage should be on done. Back taxes has to be paid upon it. Unemployment audit, social security contributions, unpaid benefit, employment law violations, and workers' compensation coverages, penalties, fines, litigation, attorney fees, and so on and so forth. That needs to be taken care for. So you need to decide and tell me: do you have to have a compliance, or we should not, or we should forego compliance? These are the compliance issues. With this, I come to an end of this particular presentation. Thank you for watching this video.